Rise. The justices of the Appellate Division Supreme Court First Department. Reading thee, all persons having business of the Appellate Division. Draw near, give your attendance, and you shall be heard.
Good afternoon and welcome to the Appellate Division. I'm about to call the calendar. Please answer the calendar and let me know how much time you will require for oral argument. I would remind you to please only ask as much time as you actually need because right now we have over 5.5 hours of requested argument. The first case on the calendar is People versus Eric Brown. Okay, we'll mark that submitted. Okay, Flores versus New York City Health and Hospital. Right, 6, 2, and 5. Maridas for the matter of Maridas. 2 cases submitted. 721 borrower versus Ben Mohawk. Is there a respondent? Do you wish to submit? I'll give you 3 minutes, okay? If we need more, we'll ask questions. Peters versus Structure Tone. 5, 2, and 5. Thank you. Narvaez versus Vornado. Do you have any specific questions? All right, thank you. We'll mark it submitted. We have your briefs, obviously. Okay, People versus Gondres, submitted. Alford versus Amchem Products. Six, 2, and 5. Shore versus AKT in motion. We'll mark it submitted. Thank you very much. Innovative risk against Morris, Duffy, and Alonzo. How much? Okay. 6, 2, and 6. People versus Armstead. 2, 3. It's a little backwards, but okay. All right, you know, we're flexible. Okay. Okay. All right, 2, 3 for the appellant and 3 for the respondent. Thank you. Gardner versus Virtuoso. Maybe it's cold out. I don't understand. We're only getting one side. Go ahead. What do you request, sir? Do we have any specific questions? Okay. Well, I'll mark it submitted. Thank you, Counselor. Markov versus Barrows.
6 and 2, please.
I'll give 6 and 2 to the appellant, 6 to the respondent. Gomez versus City of New York. Well, nobody's responding, so I'm assuming not. Okay, thank you. Submitted. People versus Jonathan Cruz. Okay, the appellant gets 5 and 3, the respondent 2. Hoffman versus Ford 709 Associates is submitted. Allied World Insurance versus National Union Fire is submitted. The first case for argument is Flores versus New York City Health and Hospitals. Please step up.
Wow. You don't see that.
What? I know. It's a quirky calendar. Okay. Okay. You can proceed, Counselor.
Thank you. Good afternoon. My name is Stuart Diamond. I'm here on behalf of the plaintiff appellant. The motion court didn't quite get what this motion was about. It decided that because the city was not responsible for what occurred at the Health and Hospitals facility, that was enough to grant summary judgment. In fact, the opposition papers raised a triable issue of fact. As the city conceded, from the time he was returned, Mr. Flores was returned to Rikers on August 29th. 8 days later, he began complaining of chest pains.
Let's just narrow this down. So the operative period that we're talking about is from 8/29 to 9/14, correct?
Yes.
Right, because by 9/14, he's back at Bellevue, and then the city defendants that are left here, they had no more responsibility for him, right?
As of 9/14.
As of 9/14. Okay, so go ahead.
So, but 8 days before he was eventually transferred, on September 6th, he began complaining of chest pains. He complained of chest pains again on September 7th, on September 11th, and then again on September 14th when he was finally transferred. As was stated by the board-certified cardiologist, whose affidavit was included in opposition to the motion, continued chest pains after an ablation are not consistent with the procedure. And he also said that the relevant standard of care for ablation patients is to maintain a high degree of suspicion for a fistula in the presence of chest pains. He had been complaining of chest pains for 8 days. So that is the operative period from September 6th to September 14th, and both the board-certified radiologists and cardiologists stated in their opposition paper, in their affirmations in opposition to the motion, that this was a proximate cause of his eventual death. The opposition papers also included a note in the hospital records from when he was eventually returned on September 14th. That note referred to an article which was cited both by the plaintiff in opposition and now in the respondent's brief. And that article, which was cited in the hospital records and relied on by both sides, indicated that a clinical indication of a fistula includes various symptoms, including chest pain and neurological deficit. He had both. He complained of chest pains over those 8 days before he was eventually transferred, and he had also at one point complained of dizziness.
But Counselor, did your expert opine as to when the fistula actually first appeared, or when it could have been first detected?
So that's based upon primarily the affirmation of the expert board-certified radiologist. There's a discrepancy because the doctor who interpreted the CTA images at the hospital on September 14th evidently didn't find any evidence of a fistula.
Well, let me just stop you there. So your radiologist said, no, the images that were taken on the 14th did in fact reveal a fistula. But the question, I guess, really is did he draw a conclusion from that about how long the fistula had otherwise been detectable?
So
how long before that?
There was no explicit statement as to when the fistula was detectable. There really was no way for the radiologist.
Right, so that was my question. So don't we need that? Isn't that necessary for purposes of determination as to, no? Why not?
Because before we submitted our opposition papers, they premised their entire argument on the September 14th images supposedly not showing evidence of a fistula.
But if there's no evidence of it, then how do you therefore argue that it should have been treated?
Because
and that
that's
it was negligence in not treating it?
Because that's the discrepancy. One radiologist said there was no evidence of it, and one radiologist said there was evidence of it. One radiologist...
But that was September 14th already, which was why I asked you about what the applicable period is. By that time, his care was turned over to Bellevue. So if we accept what your radiologist said, yes, by the 14th, when they took images, it was knowable, it was discoverable. How does that make the city responsible for the care that occurred before the 14th?
Because if it was diagnosable and diagnosed on the September 14th images, then it might have been diagnosed if images had been obtained on one of those earlier dates.
But don't you need more than might have been?
No, because it's the same argument that they're making. It's just the converse. They're relying on those exact same images to say that these images didn't show a fistula. We're saying that it did.
Well, don't you need, for example, to say, okay, so we saw it, it was seen on the 14th, right? So since it was seen on the 14th, that means that it existed, it was there, and would have been, it could have been diagnosed and seen on the 13th, the 12th, 11th,
Exactly.
10th, et cetera.
Right. And
that's not what is being said.
But if it was diagnosable on the 14th, it could have been diagnosed earlier.
Could have been, but again, based upon what?
Based upon the fact that it was diagnosable, this court, the motion court, can't decide as a matter of law just because if you accept that there's an issue of fact as to whether the fistula appeared in the images on the 14th, the trial court can't, as a matter of law, decide that that's the first day that it was diagnosable. That has to be left up to a jury. As an illustration of that, when he was
I'm not sure that's right. I mean, honestly, if there was something in your radiologist's report that was, at the time I was able to diagnose it, I saw on the 14th images, it was such and such a size. Given the rate of growth of these kinds of fistulas, it is more likely than not that it would have been diagnosable on the 11th, on the 12th. That's something else, and that is something that we do frequently see in these cases. And I didn't see it in this case, and I have to say, it troubled me.
I'll give an illustration. He was eventually diagnosed based on CTA images obtained on September 22nd. Nobody is saying that because the examination was not conducted until September 22nd, that had to be the day when it was first diagnosable. The fact that that he didn't undergo images has no bearing on whether there was a diagnosable fistula.
So, I mean, there are medical records, right, between September 6th and September 14th. And your expert didn't point to a single thing in any of those medical records other than the fact that he was having chest pains, which he didn't explain. Your expert didn't say anything about all the chest pains he had before September 6th. He didn't differentiate. There was something different about the after September 6th. And he didn't point to anything in those medical records that would have said that, the Department of Corrections missed. So what you have is, I think you should have found it on the 14th, but that's not the Corrections Department issue. That's Bellevue's issue, right? And you're saying that somehow the Corrections Department people should have, between the 6th and the 14th, found it, but you're not pointing us to anything in the record that would back up that claim.
I believe I am. On pages 533 and 535 to 537, there's indication of chest pain complaints on September 6th. On September 7th, page 541. On September 11th, page 540.
Is that in the chest pains? Is that indicative only of fistula, or is it indicative of something else? Because he had other issues as well, right?
But that's one of the indications of a fistula.
But it's an indication of something else as well, right?
Well, you're right, and that should be determined by a jury. I'm not saying that chest pains can only be indicative of fistula, but based upon the affirmation of our expert cardiologists, it was a deviation from accepted practice for them not to take the possibility of a fistula into consideration. And it's stated in that article that chest pains and neurological deficit, two of the symptoms he exhibited over those 8 days, were indicative of a possible fistula. And to go back to the issue.
You can do that on rebuttal. Let's hear from your adversary.
Thank you.
Thank you.
May it please the court, Zach Shapiro for respondents. Starting off with with causation, the city's timing of returning Flores back to the hospital couldn't possibly have delayed detection of the fistula because the Bellevue record showed that the staff there did not identify the fistula until 8 days later. As plaintiff's counsel has now conceded, they don't offer any evidence that it was detectable before September 14th, and for that reason alone.
Well, what do you say about the chest pains? I mean, that's plaintiff's linchpin here, is he had chest pains, and therefore you should have known he had a fistula. Was there anything else that you...
I think that, Your Honor, I think that goes to whether there was proper care rather than whether not suspecting a fistula rather than causation, because even assuming the chest pain was because of fistula, there's no evidence in the record, as plaintiffs concede, that the fistula would have been detectable at that time. So causation is an independent ground for affirmance. To answer Your Honor's question directly about the chest pains, as they've now also conceded, chest pains aren't necessarily a sign of a fistula. The city's expert, Dr. Phillips, explained that they're a normal consequence of the ablation procedure itself, and he didn't just assert that.
Counsel, so to that point, that chest pain is is something to be expected after this procedure. Is continued chest pain something that's to be expected after this procedure? Because it's not just simply chest pain on one day. What your opposing counsel is saying, it was chest pains for a course of 8 days.
I don't think that's actually right, Your Honor. He complained of chest pains on September 6th. He declined to take the Tylenol that was prescribed to him. Once he came back on September 7th and took the chest pains, September 8th, there's no complaint of chest pains. September 11th, there's no records between that time. September 11th, he's saying he's feeling much better. September 12th, again, no complaints of chest pain. September 13th, no complaints of chest pains. Finally, September 14th, he complains for the first time of sharp or excruciating chest pains, and that's when the city immediately returns him to the hospital. To finish the point I was making, the city's expert explained that it's a normal consequence of the ablation procedure because the heat from the radio frequency energy used during the procedure can irritate the pericardium and cause chest pain. Plaintiff's expert cardiologist says that's not true, there are no chest pains, but he doesn't explain why. He has to offer some analysis or some citation to the medical records or some citation to scientific literature to explain.
Is there any dispute that the fistula, although a possible outcome of the ablation procedure, is a relatively rare condition?
It is relatively rare. At page 678 of the record, their article identifies it at 1 in 500 on the high end to 1 in 10,000 on the low end. And only a fraction of those.
One other thing, I know just because you have limited time, is the theory in this case is that there was a loss of chance. So is there anything in this record that indicates that had the plaintiff been diagnosed at an earlier point when the fistula could have been detectable, say some days before, that there would have been a different outcome in this case?
Not at all, Your Honor. Not only is there no evidence that it was detectable before September 14th, there's no evidence that the necessary corrective surgery at that time would have been any less effective, as set out in the affirmation at pages 862 to 865 of the record.
You know, counsel, I noted that the expert, if I'm not mistaken, made reference to the fact that it's very difficult to diagnose a fistula, which I thought kind of cut both ways, because then I'm thinking, well, if it's difficult to diagnose, but it is a consequence of the ablation, then perhaps there should have been some effort to detect whether there was one or not.
I don't think so, because he didn't have any of the triad of symptoms that their medical article itself identifies as most commonly associated with a fistula. He didn't have fever. On initial argument, the plaintiffs raised for the first time that he had neurological deficit, but they never argued that before. There was no vomiting blood, which is the third symptom. So in addition, independent, we would independently based on causation, but there is also no issue of fact as to the city's proper care. Thank you, Your Honor.
Thank you. All right, rebuttal, Counselor?
Thank you. Just so it's clear, with one exception, I didn't concede any of those things that counsel said I conceded. This issue of sharp chest pains is something that comes out of nowhere. The medical literature.
So, counsel, do you disagree that that was one day and that the rest of the medical records between, say, I'm saying 2 days, the 7th and the 8th, and then there's nothing in the record that shows chest pains until the 14th?
There were chest pain complaints that were made on the 6th and the 7th and the 11th.
And then, so it wasn't a continuous every day, I'm feeling chest pains. It was a couple of days of chest pains right afterwards. Then I feel much better. I don't need the Tylenol. I'm feeling pretty good. Then a day of chest pains, and then 2 days of no chest pains. That's a lot different than I was continuously feeling chest pains, right?
Well, we
Does
don't know.
your expert explain how that not feeling chest pains every day?
It's not that he wasn't feeling chest pains. This is not indicative of when he felt chest pains. This is indicative of when he complained of chest pains.
Okay.
Well, he denied. He was asked, and he denied having chest pains. He denied dizziness. He denied shortness of
Yes,
breath,
there
et
were 2 periods
Right.
of 2 days when he didn't have chest pains. But this is we're dealing here with medical opinion.
You know,
This is
Counselor,
not
and also-
anywhere in the record.
I'm sorry, you had previously mentioned neurological issues, but I didn't see anything in the record about that. But I noted.
There was a complaint of dizziness. So, and even, there's a complaint of dizziness during those 8 days. But even
Oh,
if-
on the 7th, he reported some dizziness and
Right.
sweating, but he said it was fine after actually having a bowel movement and no chest pain.
with all due respect, it's not the court's province to make precise, fine medical determinations of this type if they're not contained anywhere in the record. And just to go back to that issue, their entire argument essentially relied on those images obtained on September 14th. And without an affidavit, in fact, they didn't even submit the report. It was just an entry referring to the report. Their doctor said it didn't show something. Our doctor said it did.
All right, we understand that. You argued that on your direct argument. You don't need to repeat that, only because your time is up. Okay? We understand that's your argument. All right, and we have your briefs.
Thank you.
Okay, thank you. The next case for argument is 721 Borrower against Mohawk. Okay, Counselor, I gave you 3 minutes. You can proceed.
Thank you, Your Honor. Charles Bulbul for 721 Borrower LLC. 721 Borrower LLC commenced this action to recover rent due pursuant to a guarantee that...
Yes, so counsel, we've read your briefs. You have 3 minutes, so let's get into it. How does Melendez affect or not affect the determination of this appeal?
Oh, well, very simply, the Second Circuit Court of Appeals ruled under circumstances that are essentially foursquare within the facts of this case that the guarantors were released from liability with no regard for need, without regard to actual injury, without regard to landlord compensation, without regard to the public interest. The tenant simply overstayed the term of its lease, triggered a $674,000 obligation that otherwise would have been forgiven had it not, intentionally violated the lease on December 31st, 2020. $304,000 of the money was due prior to the enactment of the statute, and it was never deferred, and therefore the court below made a factual error in the calculation. Paragraph 18 of the complaint spelled out on a month-by-month basis the months for which the rent was due. I did read the record on appeal in 558 7th Avenue this morning, and it was pretty obvious from that complaint that the only rent outside the statute was the March 2020 rent. I've got 2.5 years worth of rent that's outside the statute, and arguably the $674,000 is outside the statute because as I read Justices Higgins and Scarpulla's decision in 30 and 6th, it has to be a default that's triggered by the pandemic. The pandemic had nothing to do with the tenant's intentional decision to refuse to vacate the premises on December 30th, 2020. The tenant could have walked away from its obligation by simply moving out. Instead, it decided to stay in possession for 9 more months until Justice Lebovitz issued an order basically saying that they were going to be liable for $7,500 a day.
I saw on the record that there was a judgment.
Yes, the judgment is about $4.5 million right now against the prime tenant.
So doesn't that cover most of the outstanding rents?
Well, the prime tenant's completely defunct and out of business, so shouldn't the guarantors be held accountable for the obligation that they expressly assumed under the stipulation? Unlike all the other cases before the court, this stipulation, the guarantors are party to, and the guarantors undertook to vacate possession of the premises on December 31st, 2020. Why should that be excused under the guarantee law? That has absolutely nothing to do with the pandemic. Any other questions, Your Honor?
Just in terms of following up on my colleague's question about Melendez, in that case, it was like it is here, a motion to dismiss. And the court said that it's a mistake to dismiss the constitutional claim. It didn't expressly decide it, although it had a lot to say about it.
That is true. It did not expressly decide it, but the court did say that if, in fact, all it is debt relief legislation for a protected class, that is unconstitutional.
But don't we need a more fully developed record before we make any kind of constitutional decision in this case?
Your Honor, I would be more than pleased to have the court below's decision reversed so that I can fully amplify this record and accomplish that mission.
And should you not have done that below? Should you not have done that below?
I made a motion for re-argue. I tried to convince Justice Engoron that the calculations were wrong and that the stipulation didn't apply.
No, I'm saying in terms of the constitutionality argument.
We never even got to that point because he simply dismissed the case on the grounds that all of the rent was covered by the stipulation, which in fact it wasn't, and therefore it was barred by 22-1005, and I had nowhere to go but here.
Yeah, and just to be clear on the timeline, at the time Judge Engoron made his decision, the Second Circuit decision had not come out yet.
That is
true. The
true.
only thing that was on the books was the Southern District's decision, which said that the statute was constitutional.
That's correct, Your Honor, and that's exactly what Justice Engoron said in the first decision. And then when we came around to the second decision, Melendez still hadn't been decided, but this court's decision in 558 7th Avenue had come out, and therefore the doctrines of frustration and impossibility have been eliminated effectively. So the issues now that are left in this case, what rent is covered by the statute, if any, and some of it clearly is not, and if there is some of it covered by the statute, is the statute constitutional? And I would respectfully submit it's not.
Okay. I think we understand your arguments.
Thank you, Your Honor.
Thank you, Counselor.
Appreciate it. Thank you.
The next case is Peters versus Structure Tone. You can proceed, Counselor.
Thank you. May it please the court, I'm Steve Arapot from Barry, McTiernan, and Moore for defendants' appellants. This appeal concerns a particle so small that it could only have injured the worker by getting into his eye. And because it is so small, it's not really within the intendment of Labor Law 240 or the two sections of the Industrial Code that were brought under Labor Law 241-6. Regarding the Industrial Code provisions, those should have been dismissed because the plaintiff's expert provided an opinion that the only way to prevent this accident was by providing both a planked platform and a plywood platform on top of it, while the rules only require one or the other. The motion court held us to that higher level and held that we had violated it, which was error. But also, the import of the plaintiff's expert's opinion is that if you require both kinds of platforms to prevent this particle from injuring the plaintiff, then it can't be the proximate cause of plaintiff's injury that defendants failed to provide the one kind of platform that they were required to provide.
Well, you don't think that maybe there's an issue of fact about causation, whether a plank platform required under the Industrial Code would have caught the falling debris so it didn't wind up in his eye?
Well, the tightly planked platform could have allowed this accident to happen. And if it is, because the kind of tightly planked platform that occurs on a construction site is one where, made of heavy construction timbers that are reused, and they don't fit tightly together like a, finely laid floor. The gaps are wide enough to allow particles to go through.
And it also catches particles. It would catch particles this small too, depending on where they fell, right?
Yes, but it's certainly not a guarantee that this accident would not have occurred.
So would there not be any safety equipment whatsoever? Is your argument therefore that there's no safety equipment whatsoever which would catch particles of this size, and so therefore you should be awarded summary judgment? I'm not really clear.
On a construction site, there are always small particles that are blowing around, falling. You cannot make a construction site pristine so that these particles won't perhaps get into someone's eye. What the Industrial Code does require is goggles under Rule 23-1.8a, but plaintiffs specifically did not pursue that claim. And the court below properly held, because they didn't even argue it, that they had abandoned that claim.
Sir, do we know the source of the debris?
We do not know the source.
So perhaps it's possible then that there was a larger object that maybe disintegrated or shaved off a bit and created these particles, but we really don't know the ultimate source of these quote-unquote particles.
We do not know where it came from exactly. However, we do know that it was a millimeters-long metal shard, just a tiny piece of metal that happened to get into the plaintiff's eye and was only found with a CAT scan.
Well, you say happened to get into his eye. I mean, the testimony was that it fell from above, right? It didn't happen to get into his eye. I mean, because you just made reference a little while ago to perhaps it was blown in the wind or something of that nature.
Well, you can't tell where it came from.
Does that create an issue of fact?
Excuse me?
Does that create an issue of fact? Yes.
I do not want to give that up, but the court may feel differently. I would like to touch on Labor Law 240.
Let me ask you 240. We don't know from what distance that little piece of debris fell from, right?
No.
Right, and depending on how high it was falling from, might impact or might affect the impact that a small piece of debris could have, right? It's the old penny off the top of an Empire State Building or claim, right?
A penny is a significantly larger object. The fact of the matter is that a small
No, I'm talking
metal
about
shard.
the physics of it. I mean, can we really figure out now, conceitedly, we do know it's a very small piece of debris, but without sort of information about where it fell from and the physical properties of it, can we really make a summary judgment determination in your favor? I don't know.
Well,
It's
certainly it was
small, I'll
wrong to
give you
make a
that.
summary.
It's a small piece of debris.
Certainly it was wrong to make a summary judgment against defendants. But I think that it was also wrong to not dismiss plaintiff's claim, because such small particles are really not within the intendment of Labor Law 240.
They're just part of the dangers that you can expect in terms of doing the work on a labor, on a construction site?
And that is why the industrial code requires safety goggles. The best safety device against particles so small that they can only get into your eye is safety goggles, which are required and would have prevented this accident had plaintiff been wearing them. And again, there's an issue of fact as to whether plaintiff.
Yeah, you'll have rebuttal time.
Thank you.
Let's hear from your adversary.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent. Let me get to the 240 issue if I can. I think it's a little unusual to try to use the Runner decision, in which Judge Littman specifically said that the labor law was being construed too narrowly for the protection of workers, to create an exception to falling object liability because the object is small. I would ask you to take a look at pages 310, starting on line 1 to 311, line 4. I'm not going to read it. I know you probably know it. That's Mr. Victor's testimony where he says that not only is this something that was foreseeable, but it was something that was preventable with plywood or tow guards. And the only case that we could find, I don't think there is another case, is the Galarza case. I know it's a lower court decision, but we are dealing with an absolute liability statute. 240 is supposed to be construed broadly for the protection of workers. And the fact is that in the worst case scenario for me, this object fell from the 11th floor to the 10th floor. It could have been even bigger. So I don't see any doubt about the facts at all. And I would just, Judge Gish, you asked something about the fall. You don't know where it came from. There's a case I'd like you to look at. It's yours. It's Humphrey against Parkview Fifth Avenue Associates. It's at 113 AD 3D 558 at 559. And you said this, not Brian Isaac, this is the First Department. The fact that plaintiff did not see the beam hit the stringer or know where the beam fell from does not preclude partial summary judgment in his favor, as the testimony demonstrates that the beam came from somewhere above the plaintiff and was a proximate cause of his injuries.
But a beam is significantly different than what we're talking about here in terms of the size of what fell. And I know it's been characterized by the parties differently at different times, but we do know the measurements of it because of his medical records, what they were able to get out of his eye. And it was about 0.5 centimeter big, right?
That's correct, except he said what got in his eye is not necessarily what fell on him. Remember, he said that he fell on, that construction debris was coming down. He also said, and this isn't disputed in the record 138 to 140, that in a previous situation, he was in the shaft and concrete fell on him. So it's not an unforeseeable event under your decision in Ortega, and I keep saying Jones against 414 equities because obviously I lost that case, but Jones says that foreseeability in the context of a 240 case is fundamentally different from foreseeability in the context of a negligence case. It's foreseeability, it's site foreseeability. If you can see by looking at the endeavor that there's an elevation-related risk, you've established foreseeability. So I don't think that we should be talking about the size because small objects can cause injury to people.
No, but it really isn't it, counsel, an issue of whether or not that this is a labor law question? Dust happens. Little tiny particles happen. The question really is, and it could be a question of fact, is whether dust falling down or little particles falling down is intended to be covered or could even possibly be alleviated but with a, other than wearing goggles, which I think is not a listed thing in 240, whether the statute applies. That's the whole point. I mean, is there anything that could, your expert says, put up a plank and you don't get it, but that's not universal. I think the defendant says that's not going to prevent dust from flying around and getting into someone's eye. So the question really is, the question of fact is whether or not the statute applies to this particular situation.
And can I address that, Judge Scarpullo? Because it is an important point. I said, the reason I directed you to 310 and 311 is my reading of that testimony from Mr. Martin, that's a defendant's witness, is that this is preventable. And I also
want to... Can I just say that everyone in this case testified more than one time, completely differently. Some people signed affidavits that said something different. People signed accident reports that didn't quite mesh up. Everybody's saying a lot of different things.
Well, but nobody says that the plaintiff didn't get something in his eye.
No,
everybody
But how it happened and whether it could have been
Correct.
prevented, everybody said completely different things at different times.
But
There's not consistent testimony about that.
But it has to be a material deviation. In other words, you've had your decision of law from Orellana to John to, I finish? Beharstani.
You can finish, and I have another question
Sure.
for you as well.
It says that it has to be material. So if in fact there's protection that's required, my view is that's a question of law, because juries can't make that determination. It should be something for the court. Is the labor law, does it require this type of guarding? And the defendant's own expert says, yes, it does, because we put planking there even though it wasn't there, and he's basing it on the incorrect photograph. To me, that's a question that the court can determine as a matter of law, as opposed to having a lay jury to say, well, what does 240 of the labor law require? That's hard enough for lawyers, probably hard enough for judges, and it's certainly going to be basically impossible for jurors unless they're tort lawyers.
I think we do that, though, right? We do leave that to juries.
When there's a question of fact, but I don't think there's any question of fact that something fell from above the plaintiff and got in the plaintiff's eyes.
But is that enough? And here's my question to you. Under our case law, it's not just that something falls. There's got to be something more to it. So under Wilinski and Runner, you have to look about the elevation differential, whether it's significant versus de minimis, and the weight of the falling object. Here, this falling object didn't have much weight, and the amount of force it was capable of generating, even over the course of a relatively short descent. So in most of the cases, you have a big object that just goes a little bit and it generates a lot of force, and the Court of Appeals says, well, those will qualify. Here we quite frankly have the opposite. We have a little teeny tiny object, and it fell at least a story, maybe more, but we don't have any information here about the force that it was capable of generating. So I use the example with your adversary about the penny off the Empire State Building. You know, don't we need that kind of information in the record before we can figure out liability under the statute as a matter of law?
Well, Judge Gish, you know my answer is going to be no. Let me try to give you a reason why it's no, okay? Wilinski dealt with a different situation. We know that Wilinski overruled Misrepresentation when it talked about the same level. So we're talking about something on the same level.
But they were focusing on the fact that it was a big, heavy object that fell.
Correct.
Right?
Because,
so we're the opposite here.
Because it's on ground level.
Right.
And I'll get to my point because you'll see it. It's temporal.
I'm going to let you get to your point.
And then
I asked the question.
Yeah, well, I'm going to do the best I can to answer it. And then in Runner, we're talking about an injury that actually was not a descending injury, it was an ascension injury. The heavy reel of 800 pounds forced the plaintiff's hand upward, not downward. Here, the distinguishing factor is We know in a worst-case scenario for me that this was on the 11th floor. So we have a floor differential. That's the worst I'm going to have. In that situation, it would make no sense to say Labor Law 240 doesn't apply because of this hypothetical. Assume that there are two people on this shaft instead of just the plaintiff. Plaintiff gets hit in the eye with a small pebble, and someone else gets hit in the head with a concrete piece of debris. One plaintiff wins, one plaintiff doesn't. That doesn't seem fair. It doesn't seem logical. That's the scenario that I think triggers 240 of the labor law here. I see my time is up. If you have any more questions, I'll stop talking.
Thank you. Rebuttal.
The other scenario that could be triggered here is that every particle that gets in someone's eye on a construction site is a Labor Law 240 claim.
Doesn't this really trace back ultimately to you have two types of 240 cases? We've got the falling worker and the falling object. And we've got falling object here. And it used to be up until 15, 20 years ago, she had to show that the matter that fell, the object that fell was being hoisted. Now it's either it was being hoisted or it was an object or matter that needed to be secured, right? So again, if we don't know the source of this debris, how do we know whether that item needed to be secured?
Well, I think this case should be decided like the Second Department's Moncayo case, M-O-N-C-A-Y-O. In that case, the plaintiff was standing outside a building and a piece of debris that someone was chopping into smaller pieces to put on the floor and then bag, one piece happened to fall onto the windowsill and then bounce out the window. So nobody was working above plaintiff. It was simply that this small piece happened to get out of its intended area and fall. And the Second Department held that was not an object that required securing for the work. That was a piece that was just supposed to go on the ground. It happened to get out the window. This is a kind of analogous case because no one was working in the shaft way above plaintiff. However, somebody perhaps walking past kicked some grit into the shaft way, or maybe somebody sweeping swept something in. Either way, that was not something that should have been secured where it was, and was not, it didn't make this area a place where falling objects were expected. Unless you have any questions, I will rest on the brief.
Thank you.
Thank you.
Both. And the next case for argument is Alford versus Amchem. Proceed.
Good afternoon, Ryan Sweeney for Defendant Appellant Oldenburg. In this product liability action, New York courts cannot exercise personal jurisdiction over Defendant Oldenburg, which is sued here as successor to a product manufacturer by the name of Lakeshore. This court should reverse the trial court in their decision denying Oldenburg's motion to dismiss because New York's long-arm statute at CPLR section 302A does not authorize jurisdiction here, and the due process clause forbids it. Here, Lakeshore has shown by documentary evidence that the very product plaintiff alleged encountering, a winch which is used on a ship to raise and lower cargo and anchors, was sold by Lakeshore from their manufacturing and headquarters in Michigan and sold to a shipbuilder by the name of Ingalls in Mississippi. Ingalls took these products, put it on the ship that they were building, and sold that ship to plaintiff's employer, Moore McCormack. Moore McCormack took possession of this ship in Mississippi and then sailed throughout the world, including ports in New York. This is a unilateral act of a third party and Lakeshore and Oldenburg has no connections in New York related to this cause of action, and for that reason, jurisdiction is not proper.
Don't you have to look at those two things separately? First, you look to see the minimum context. Did Lakeshore otherwise do business in New York such that the context sufficiently otherwise it would connote jurisdiction? And then the secondary issue, which is something that came out of the Bristol-Myers Squibb case, was the idea that then we look at the context or the company's, the nexus of the claim to the context, right? So Lakeshore did have contacts in New York, apart from the cause of action. Let's leave that aside for right now.
Plaintiff points out that on another occasion, Lakeshore had one sale to the Brooklyn Navy Yard. Plaintiff did not encounter that Navy product or that Navy ship. We know for a fact that the product they encountered was sold to Ingalls in Mississippi. And under the Supreme Court precedent in Walden v. Fior, Goodyear, Worldwide Volkswagen, that just because the product ends up in the forum state does not authorize jurisdiction. That's a unilateral act of a third party. Under the precedent in both New York and the Supreme Court, defendant needs a volitional act in the state, and the cause of action has to arise from that act. That's not the case here.
Well, doesn't the Ford case kind of ameliorate that second piece of it? There's got to be a nexus, but it doesn't have to be a causation.
No, Your Honor, and I'll tell you why. The Ford case, Justice Kagan, in writing for the court, said for a defendant like Ford, which has in-state distributors, dealers, recall centers, service centers, and resale centers, multiple in-state services for that product, even though it was sold out of state, they serve that product in-state, and given all those connections, jurisdiction was proper. Here, Lakeshore doesn't have any dealers or distributors.
Well, there was no, in Ford, there was no evidence, and Kagan's decision didn't go on the fact that the particular cars that were involved in the accidents were serviced in the state in which the tort occurred. She just said that they did business such that a resale of a Ford car that was otherwise defective would subject them to jurisdiction because the tort occurred in the state and they otherwise had the minimum context of generally doing business. And I guess that's really what I was getting to with your client. Did your client, apart from this cause of action, let's leave that out of the equation right now, otherwise generally do business in New York?
There are at least one other sale to New York to the Brooklyn Navy Yard, but looking at the Ford case.
And is that it?
I know.
That's the one sale that we have a record of in this case.
So, counsel, it is your position that that is not enough to show that you are doing substantial business in New York? Other than the other one sale, is there any evidence of you doing substantial business in New York?
There's no evidence of us doing substantial business in New York such that we are subject to jurisdiction here. And looking at...
And the second piece of it is you say that there's no nexus to the tort that occurred in New York.
Right, there's no nexus here because we know exactly where this product was sold to, and it was not sold into New York, and there's no volitional act on Oldenburg or Lakeshore's part to put that product into New York. Looking to, again, the Ford case, critical to that case was the many, many contacts Ford had in the state, the numerous centers and distributors that they had, and looking at the New York Court of Appeals case in Lamarca, again, what's required there was that defendant sold the product to New York, to their distributor in New York, and that allowed them to be held into court here. Without that connection, without that nexus, jurisdiction is not proper.
Okay, thank you.
Good afternoon, Jason Weinstein for Plaintiff Respondent, the Alford family. In this case, Mark Alford was exposed to asbestos in New York from products manufactured by a defendant, specifically to be placed aboard ships that were owned by a company headquartered in New York and whose ships did 80% of their traffic going through ports in New York. And that's exactly how Mr. Alford was exposed to asbestos 86 times in the Port of New York during his 12 years aboard the two ships in question. In terms of just going back to...
Well, can you establish jurisdiction through the acts of a third party?
Well, under 302A3, what we're talking about here is a defendant who committed a tortious act outside of the state, which is the manufacturer of a defective product or failing to warn regarding the asbestos in that product, which causes injury to Mr. Alford inside the state. And in an asbestos case, the injury is considered to be the exposure to the asbestos.
Right,
So,
but under the Court of Appeals decision, under the Williams case,
That's right.
we have a two-tier analysis here. First is we look, are you within the strict structures of the statute, right? So now you've said to me why you think we're just strictly within the long-arm statute.
Right.
But then you have to satisfy all that lovely stuff that's in...
due process.
Due process, right, we'll call it that, but as recently articulated by the United States Supreme Court in recent cases like Bristol-Myers Squibb and the Ford case. So how does it comport with that?
Well, let me point you first to the Supreme Court case, an international shoot, which is still good law. And it doesn't require necessarily...
It's certainly cited a lot, right?
It's still cited, it's still vital.
I know it is.
Absolutely. And it's a showing of minimal contacts such that the defendant purposely availed itself of the privilege of doing business in the state such that it would be reasonably anticipated being hauled into court there.
Right.
Now,
So, counsel, let me just ask you this. Can I just
sure.
make this a little sharper rather than talking about international shoe? Your position is that the plaintiff contracted the asbestos here in New York?
That the plaintiff was exposed to asbestos
So,
here in New York.
under your scenario, anybody who came into New York one time and was on that boat, regardless of anything else, could sue here for injury in New York?
Absolutely, under that section of the long-arm statute, yes.
You think that that's enough? I come in one time on vacation, I go onto my brother-in-law's boat, and I may or may not have contracted asbestos then. That comports with due process?
Actually, it does, ironically enough, and actually frustratingly enough, most times for plaintiffs, personal jurisdiction is really dependent on the contacts of the defendant, not on the contacts of the plaintiff. So to the extent
in most
that...
cases, let me just interrupt you for 1 second and say, you would agree with me, in most cases, it's pretty clear where the injury occurred, right? And if I get into a car accident in New York, the injury occurred in New York. If my car blows out in New York, the injury occurred. In asbestos, it's who knows where it occurred. You're saying exposure here in New York is enough. So anybody in the country who comes into New York and gets exposed to asbestos, that's enough to confer jurisdiction?
Yes, Judge, it's long been accepted both within NICAL and generally in New York.
Wow, I don't know.
The situs of the injury in an asbestos case is the exposure as opposed to where the disease ultimately develops.
Except in the context, I don't know that it's come up so much. I haven't seen it come up so much in a situation where the plaintiff's not in New York, the defendant's not in New York, there's no other contact in New York except the lawyers are here, right? So I don't know that this has come up in this context.
Your Honor, in NICAL, it has absolutely come up. I mean, to get a case in NICAL, specifically the exposure has to be within New York City.
I know, but that's not going to guide the analysis here, quite frankly.
Sure.
And a lot of the cases that came in through NICAL predated the recent Supreme Court jurisprudence on long-arm jurisdiction. So it's an interesting point that it was well accepted that you could proceed in New York, but the game changed when the Supreme Court started looking at these long-arm jurisdiction statutes and put in this nexus connection. I don't know where it's going to wind up, but I think it did change the game from what was believed when NICAL first kind of started its regime of having cases.
Sure, I see my time's up, but if I may, I really would like to address Williams versus B. Miller and how it specifically
I'll let
relates.
you, because I think this is a significant issue, so I'll give you
Okay.
just,
So
I'll give
in
you a
Williams
couple of
versus-
minutes, no more.
Sure, in Williams versus B. Miller, in a lot of ways, that's actually it's factually similar and dissimilar, because what happened in Williams is that there was a gun
No,
sale
we're familiar with it.
in the state of Ohio.
Yeah, we're
A shooting occurs in New York.
familiar with it.
Okay,
We're familiar.
so the key difference between Williams versus B. Miller in this case is that in Williams, the defendant was actually, to the extent that the record expressed it, the defendant had absolutely no reason to believe or to suspect, to reasonably expect that the gun would actually be sold or used in New York, because what happened is that there were conversations in which Bostic said he planned to open a shop in Ohio and wouldn't mind having a shop in Buffalo. Whereas here, Lakeshore designed and sold these winches specifically to be placed aboard more McCormack boats, which is a company, again, not just headquartered in New York, but it ships.
I'm trying to be, what's the word? Generous about time, but you are over your time. And
Sure.
so to go in this exquisite detail about the case that we do know the facts of your case, we know the facts of the Williams
Sure.
case,
But that is the crucial way that this case is distinguished from Williams
So
versus
you're saying
B. Miller.
foreseeability can create jurisdiction, long-arm
It's-
jurisdiction?
Well,
Even if it's through a third
For
party?
due process, the defendant
even
has
if
to
it-
have
even
an
if-
expectation that they might be hauled into court in New York. Here, the defendant
Based
did.
upon the business that they do in New York, I think. But
Or
we'll look into it.
based upon the sale of the products. If a
Through a third
retailer,
party who brings it in? I'm not sure.
not
It goes
based,
that
not
far,
based
but
on the plaintiff.
We're gonna look at it. Right,
Sure.
I understand. You need to look at the defendant's conduct, and then you go to the nexus issue. That's how I see it. Okay.
Thank you.
We'll have rebuttal.
Thank you, Your Honor. First, the foreseeability issue is in 302A3II, which plaintiff has waived because they did not preserve it in the lower court. They did not rely on that provision, so anything about foreseeability or reasonable expectation is waived. Second, they highlight more McCormack's New York context, but again, Lakeshore sold to Ingalls. There's a note in the sales log that they wound up on more McCormack ships, but again, that's a third party, not anything to do with Lakeshore. Lakeshore sold to Ingalls. What happens from there is not something that they had control over. It's not their volition, so it doesn't serve.
So even at your point is, though, even if they knew that their parts were going to be put on ships that were going to be sailing up to New York and used in New York, that's not a basis for jurisdiction.
But by that same logic, they would be subject to jurisdiction in Italy and France where these ships served.
Well, I won't speak to what the jurisdiction laws are in Italy and France, but, your analogy in terms of going to any other state in the United States is well served.
Wasn't the foreseeability issue dealt with by the Supreme Court in Walden versus Fiore?
Yes, Your Honor, and there they found that foreseeability is not enough because there, the law enforcement who seized the money in Georgia, in Atlanta, Georgia, knew that that person was going to Nevada where they were home. They knew that, but just because the defendant foresees where that product is going or where that's going does not create personal jurisdiction. If there's nothing further, Your Honor, it wasn't reasonable for Oldenburg or Lakeshore to foresee that it would have consequences in New York and that CPLR section is waived because it wasn't preserved. And finally, the Context of Moore McCormack is irrelevant to Lakeshore, and for these reasons, the trial court should be reversed, and Oldenburg's motion to dismiss granted. Thank you.
Thank you. Thank you both. All right, the next case for argument is Innovative Risk versus Morris, Duffy, and Alonso. You can proceed.
May it please the court. Andrew Bluestone for appellant. Your Honors, in this case where there were dual motions for summary judgment, it is argued here that the plaintiff's motion for partial summary judgment should have been granted upon the showing of departure, proximate cause, and potential damage to be inferred from the pleadings. It was only a partial motion for summary judgment. The plaintiff demonstrated both standing, privity, near privity, equitable subrogation, and assignment in the papers that were before the court. And having done that, it's absolutely clear that the defendants departed from good practice in the way they managed discovery in the personal injury case. On the eve of trial, as the lower court judge himself...
Let's focus on the standing issue, if you would. Go ahead.
Oh, you want me? Okay, so...
Yes.
I
I could ask specific questions, but I'm going to give you a little free rein. We want to hear your standing arguments.
Says that they were standing?
Yeah.
Because there was assignment. The general obligations law allows assignments of legal malpractice claims.
Well, you didn't have a signed assignment, did you?
Not assigned. Well,
you
they
had
have the
emails going back and forth,
yes.
Right?
And between people who do business completely all the time together on a regular basis.
Yeah, but that doesn't relieve them of the obligation to have the elements of what otherwise would constitute an assignment, just because you know people,
well,
right?
I think that's an open question of fact.
Well, the question is whether there was any privity between the plaintiff and the defendant. Was there privity?
There was privity because the plaintiff hired the defendants, paid them, and the defendants themselves, under Alliance and Prudential, knew that the work they were doing was being depended upon by the plaintiff. So yes, there was privity. Now, if you want to say that there was some break in the privity because there was a third party in the triumvirate of insurance company, attorneys, client, that may be a factor to be determined by a jury.
But was there an attorney-client relationship?
Well, there was an attorney-client relationship between the attorney and the personal injury defendant, but there was an attorney-client relationship between the insurance company and the law firm that they hired to do the work, because there was an agreement to do the work, there was reliance upon the work that was being done, there was an understanding by the attorneys that the work that they were doing was being relied upon by the insurance company in order to make decisions about settlement, and the insurance company reasonably relied upon the advice and the analysis given by the attorneys. In this case, they were withholding information about the lack of discovery and the problems that they were facing. But yes, there was privity, absolutely.
Did plaintiff insure the insureds?
I'm sorry, I didn't...
Did plaintiff insure the insureds?
Plaintiff was the assignee of Arch who insured the insureds.
So again, how does that constitute the subrogation that would lead to privity?
It constitutes both privity, near privity, assignment, and equitable subrogation on behalf of plaintiff.
Well, your client didn't pay the claim, so how do you get equitable subrogation?
Right, and also, was there any obligation on your client to pay?
There was no obligation on my client directly to pay, but my client was associated with, in a business relationship with, and obtained the assignment from Arch, who was obligated to pay and did pay. All of these things were decided as a matter of law without any testimony before the court or without a jury making a decision upon the credibility of the witnesses. And it was undisputed that there was an assignment. All the defendants did was argue that it wasn't good enough. They didn't put any contrary evidence before this court on a motion for summary judgment that there was no assignment. They merely said there's no assignment. And that's where they ended their argument.
Well, if your assignment is based upon a series of emails, can't you determine as a matter of law whether the emails otherwise constitute a valid assignment?
Yes, but I don't think you can say as a matter of law that the affidavits and the emails together are not sufficient as a matter of law to show that there was an assignment.
Well, doesn't the email indicate that the assignment, if it happened at all, was to an entity known as Programs Plus and not the plaintiff?
It does say that, and if you look at the Wesley Harris affidavit, it testifies under oath that there is a that plaintiff is a related entity. That's in paragraph 11 of the affidavit, to Programs Plus and operates with authority from Programs Plus and insurers such as Arch who participate.
Well, that doesn't mean that the assignment went from Programs Plus automatically can be looked at as applying to your client. I mean, that's where I'm having personally a disconnect here. I know you keep saying, but they said in affidavits, but so what? I mean, if the assignment is in fact the series of emails, assuming that they can otherwise measure up to an assignment, I'm not sure, but let's say they can, it appears that the assignment went to Programs Plus. The fact that your client and the plaintiff were related entities, I would look at you and say, well, so what? You know, insurance companies have lots of related entities. It doesn't mean that they kind of take each other's rights and they can do whatever they want. It's not really a question, that's just an observation. So you'll have time on rebuttal. Let's hear from your adversary.
Good afternoon. I will speak to the standing and assignment issue, as that was the focus of my adversary's argument. We have not conceded that there is an assignment. There was never an actual assignment that was produced in discovery. The only thing relied upon by the plaintiff to establish what they believe was an assignment was a series of emails. And the emails specifically state an intent to assign Arch's subrogation rights to Programs Plus. Programs Plus is not plaintiff. They are a separate entity. And that does not establish that any claims were assigned. It is our position that they had no standing to sue. And the two affidavits that were submitted by plaintiff, one from Mr. Harris of Innovative and one from Arch, are inconsistent, first of all. The Arch affidavit said that the assignment was to plaintiff, and the Wes Harris affidavit said that the assignment was to first employers.
Well, those affidavits, do they rely on anything outside of the emails?
No.
Let me finish.
Sorry.
For their conclusions that, in fact, there was an assignment? Do they say, gee, we had conversations and it was agreed that there was an assignment?
They specifically rely on these emails, and it was more hearsay that they don't say they were a part of any agreements. They say, oh, that there were these verbal discussions. Neither of the Arch affiant or Mr. Harris say that they were a party to these conversations. They weren't part of the email chain. They weren't involved in any discussions regarding a purported assignment. So I think, you know, at the offset, that is a big issue for plaintiff, is that there is no assignment. You know, the second issue is the lack of an attorney-client relationship between plaintiff and my clients. The plaintiff did not retain my clients to represent the Arch insureds. They were assigned to represent the Arch insured. There is no attorney-client relationship. There is no privity relationship. In order to establish privity, there have to be, between a third party for a legal malpractice claim, there has to be allegations of fraud, collusion, or malicious acts. That is not there. When counsel is bringing up this near privity relationship, which is not something that was raised in the complaint, it's not alleged, that deals with a negligent misrepresentation claim, which there is no such claim in this case. There's no allegations that any misrepresentations were made to plaintiff in order to compel them to settle. In fact, it was not plaintiff who authorized the settlement, it was Arch. Plaintiff did not want the case to settle. And this court has considered a very factual situation on 3 different occasions in the Risk Control Associates Island Group case, insurance group case rather, where it was the same situation. It was a TPA, like plaintiff, that was suing an insured's attorneys in a personal injury case. And on 3 separate occasions, this court decided that there was no near privity relationship because there was no contractual obligation for the TPA to pay the underlying settlement, and there were no actual damages. And this is the same situation here. Plaintiff did not pay any portion of the settlement. The entire settlement was paid by Arch. This isn't disputed. This was testified to by Mr. Harris. We have the proofs of payment. Plaintiff didn't pay anything towards the settlement. And then just finally on the actual substance of the legal malpractice claim itself, even if you put aside the issues of lack of standing and the lack of an attorney-client relationship, you get to the causation element of the claim. And basically what plaintiff is saying here is that, you know, because these expert witness disclosures were
late.
Allegedly served late,
Yeah.
that the settlement was excessive. The problem here is that my clients consistently valued this case to the $750,000
I
range.
saw that, though, but on the underlying malpractice issue, is that something that we could determine as a matter of law?
Well, the problem is what plaintiff needs to do to prove their case is to establish that if the experts were not going to be precluded, they weren't, there was no decision, that the result in the underlying case would have been different. Either it would have settled.
We understand the
right.
but-for causation. We understand that.
They haven't done that. You know, you're looking at the underlying plaintiff's attorney had already won summary judgment on liability that was accruing interest for over 2 years. She was a passenger in the car. You had her attorney that was requesting the policy, made no indications that they were going to settle. You had the underlying judge pushing a settlement in the $750,000 range. You had my client repeatedly, you know, valuing the case consistent with other jury verdict values. There were no prior pre-existing injuries. The underlying plaintiff had 3 surgeries. So, you know, plaintiff cannot establish that the result would have been any different, either a defense verdict if it went to trial, or a better settlement, or a verdict better than the settlement amount. It's just completely speculative and conjecture. And then just finally, we believe the trial court was correct in dismissing the breach of fiduciary duty claim as duplicative of the legal malpractice claim, and also dismissing the breach of contract claim because there was never any contract between plaintiff and my clients that was produced.
Okay, thank you.
Thank you.
Okay, rebuttal.
So as to misrepresentation, there was misrepresentation alleged and shown from the expert's opinion in that they'd never reported to any of the plaintiff that there were problems with discovery, that they hadn't filed their discovery responses, and that they were in jeopardy of having everything precluded. It was only after the full morning of Judge Taylor racking them with regard to what they were doing and why they were trying to put in expert reports on the eve of trial that the case was effectively compelled to settle. That having been demonstrated by the expert report, and that the expert report submitted on behalf of plaintiffs showed that there were departures from good practice, which proximately caused a bad result, and that in his opinion, it was an excessive payment. And the court then, as a matter of law and as a matter of fact, determined what the value of the case was and says that it wasn't excessive. The court didn't have sufficient opportunity or ability on a motion for summary judgment to make such a factual finding. With regard to the losses, they were losses by Arch. There is no statute of frauds issue with regard to an assignment. There's no obligation.
No, but well, let's just go back to that. You're saying, okay, we have some emails assigning from one person to another person, and you're saying those are examples of an assignment, even though there isn't any consideration set forth in those assignments. Let's even assume that's true.
Right.
And then there's no assignment from that entity to you. And you're saying it's enough for you to put in an affidavit from someone who says that they're affiliated, absent a second assignment? Have we ever held that before?
You certainly have, especially where Arch,
Tell me what case have we
I don't have,
said?
I don't have the case for you.
Right, exactly. I don't think we've ever said that it's enough to show an assignment to say from assignment number 1 to assignment number 2 is good, and because someone puts in an affidavit and says I'm affiliated, that second assignment is good. I think, in fact, if you look in the mortgage foreclosure cases, we have consistently said that is not sufficient.
But in the mortgage foreclosure cases, there's a statute of fraud issue. There is no statute of fraud issue in here because there's no requirement that there be a writing. Mortgage cases, yes. Here, no. And that's a major difference. Let me say this. I don't believe that Arch putting in an affidavit is insufficient as a matter of law so that summary judgment could be granted.
Doesn't matter if the person putting in the affidavit was not a party to the conversations that he or she is relating.
No, it's Arch putting it in through their selected person.
Based upon what? They weren't even a part of the email chain.
Arch wasn't a part of the email
The
chain?
individual who put in the affidavit, was he part of the email chain?
I believe she was part of all the discussions. I don't know whether she was part of the email chain. Arch certainly put in an affidavit, and there were emails from Arch saying, hey, we're assigning. Thank you.
Okay, thank you. Thank you both. Okay. People versus Armstead. Okay, you can proceed.
Maybe please the court, my name is Laura Boyd, counsel for appellant, Ms. Armstead. In this case, the trial court was wrong when it said that appellant did not provide sufficient factual, sworn allegations of fact to warrant a MAP hearing. In fact, it was the prosecution that failed to provide sufficient sworn allegations of fact establishing the lawfulness of the police conduct.
So, counsel, do we even get to that if there's a valid waiver of a right to appeal?
If there's a valid waiver?
Yes.
No.
Okay,
We have
so
argued
is there a valid waiver?
there is not a valid waiver.
And why is that?
Because the waiver was at best a muddled discussion by the court, told appellant first that the waiver would mean that after sentencing, the conviction would be final, and that there would be no further appeal and no assignment of counsel. As an afterthought, the court added in, oh, there are some things that survive the waiver, but it did not clarify that appellant would have the assistance of counsel and be able to raise these claims. And given that appellant has no experience with New York criminal justice system, her ability to figure out the muddled meaning of what the court explained was she couldn't do that.
Did she have an attorney?
Yes, she did.
Was the attorney present at the time of the plea and the waiver?
Yes.
Was there any colloquy from the court to the defendant as to whether she spoke to her attorney concerning the waiver?
Yes.
And did she say did she say that she had spoken to her attorney and
Yes.
that she understood the waiver?
She said that.
But we don't believe her.
But we don't know what the muddled advice.
How was this muddled? You used that term previously. How was this muddled?
Because initially the court told appellant that after the plea and sentencing, there would be no further review. It would be final because of the waiver. But then after that, the court said that certain claims survived, but did not explain that as to those claims, she would have the assistance of counsel and be able to go to the appellate division.
So the court talked to her about what would happen after a guilty plea, conviction, right to appeal, you get a free lawyer, you go to the appellate courts, complain if something is illegal or unfair.
Sorry, I didn't hear you.
The court also said that you can complain to the appellate courts here if something's illegal or unfair had happened, and you'd get a remedy for it. And so do you now want to waive your right to appeal? And also the court said, have you spoken about all of that with your counsel? And she said, yes. Are you prepared now to waive your right to appeal and sign that waiver here in court? Yes. Then the court said, I also want to mention to your benefit, and then went on to talk about things that were not covered by the waiver.
Yes.
Right? So how is that muddled?
Because the first part of the court's explanation was that the case would be over, there'd be no further review. The court never backtracked from that statement.
The lawyer, no. Any defendant has a right to appeal the conviction to a higher court. That would mean you get a free lawyer if you needed one. That lawyer would go to the appellate courts and complain if something illegal or unfair happened here, and you would get a remedy for that.
But it goes on to say, the court, that the waiver means that when I sentence you in this case, it will be over and there will be no further review.
Yes.
So we're asking somebody who has no experience with the criminal justice system to know that.
Well, counsel, you're hinging your entire argument on that one sentence. But in fact, even if that sentence, if we were to concede that that sentence is inaccurate, which it is, right? The court later on corrected itself, and in addition, there's a written waiver. There's a written waiver that was executed here that clarifies or dispels any misstatement by the judge. Why isn't that enough?
Going to the written waiver first. The court never specifically inquired into appellant's understanding of the written waiver. It just asked if she had discussed it with the lawyer, but we have nothing on the record to show what she understood about the written waiver. And as for the other things the court added in for her benefit, it was thrown in as an afterthought, but the court did not clarify that when it said the case would be over, that meant for those residual things that could be raised, she would have the assistance of counsel, she could go to the appellate division. It was basically, it's over, but there are these other things that survive.
Okay, thank you. Let's hear from your adversary.
May it please the court, Molly Morgan on behalf of respondent. The appeal waiver here is valid and enforceable because the court...
Can we go to the secondary issue for a moment, which is whether she should have gotten a hearing on the suppression motion, right? One of the questions I have is I'm looking at the judge's decision on the motion, and he says that the people don't intend to use the evidence that they recovered as evidence in the trial, right? That's what he says. Does you're shaking your head. You have to.
Yeah, I'm sorry. Yes, that's correct, Your Honor.
Right,
He said
right.
the court did note that.
Right. How could that be? It was a weapons possession charge, and the evidence that she was looking to suppress was the gun that was taken from her purse. So that would seem to me to be incorrect. Am I wrong?
No, you're not wrong, Your Honor. I can't really speak to why that statement is in there. I would argue that it's not really connected to the court's reasoning, and in any event, the court's decision in this case was so clearly proper that that statement doesn't require any remedial action by this court.
So the court was concerned that there wasn't a lot of detail in her motion, right?
That's correct.
No, but isn't the level of detail that's required dependent upon what the defendant had available to her in terms of knowledge, right?
Yes, that's correct, Your Honor.
So did she know at the time she made the motion that there was an undercover police officer that was working the case?
I can't speak to whether she knew that specifically.
Well, wouldn't the undercover officer's information or the information relied by the undercover to the defendant, or excuse me, to the arresting officers be germane in whether there was probable cause to arrest and to search her pocketbook?
No, she did not need the contents of that communication in order to provide her own facts regarding, one, what happened in the hotel room, which were completely within her knowledge as she was the only other person inside the hotel room.
Well, she didn't have to implicate herself in a crime. She said that as far as she knew, when the police walked in, what they saw was her in a hotel room with a man, right? Is that wrong?
That's not wrong, Your Honor, but she doesn't.
That in and of itself, that view is not a crime, right?
It's not, Your Honor, but another important factor in this is that I think the context of the motion and the pleadings make clear that if I might just finish up, did make clear that there was a communication. Defendant never alleged any facts regarding, basically, if she, to her knowledge, believed that a communication had occurred. And given all the context of this, basically her theory is that these undercover officers barged in the hotel room right at the exact moment that she had just finished discussing this transaction. And
the law enforcement, not the undercovers.
Yes, I apologize. Yes,
I understood what you meant.
So,
right.
But again, I'm not understanding, why were the allegations that she set forth in the motion to suppress, why were they insufficient?
They were insufficient because, for two reasons. One, she failed to basically rebut the basis for the probable cause for her arrest, which was clear based on the pleadings. And two, she hasn't set forth any reason why the communication would provide some other basis for suppression. This is completely different from the street-level buy and bust situations where the communication itself can provide a separate basis for suppression under People versus Dot because there's an identification issue. Here we have no such issue. She was the only person in the room, and therefore that communication couldn't have provided a basis for suppression without her also having denied engaging in the undercover transaction.
Well, here also, she was not only charged with a weapons charge, but she was also charged with prostitution, correct?
That's correct, Your Honor.
So are you suggesting that because if she had admitted to the communication, she would be admitting to prostitution, and therefore that's why she did not, there are no allegations as to the possession of the weapon in the purse?
No, Your Honor, but having engaged in that transaction with the undercover officer was the basis for them to enter and seize her, and she failed to provide any facts regarding what went on there.
In your view, does she deny the basis that would establish probable cause for the arrest of prostitution?
In my view, no. I think strictly reading her allegations, that she engaged in no observable unlawful behavior and that nothing illegal or suspicious was an open view. I don't think that's a denial of having engaged in the transaction, but in any event, typically just saying that you were engaged in innocent conduct isn't enough without also providing your own facts regarding what the basis for probable cause was.
But she should have said more in terms of why she was in the hotel room, why she was in the room?
Yes, Your Honor.
Would it have been enough to just say that she denies that she was engaged in the prostitution act or something related to prostitution?
Perhaps that would have been a little bit closer than the vague allegations that she did offer, which said absolutely nothing about what was going on. Unless the panel has any further questions, we ask that you affirm.
No, thank you. Rebuttal?
As to the merits, the prosecution was the sole body in control of the information as to whether or not the undercover communicated anything to the arresting officers. Appellant has no ability to know that. She cannot say there was or wasn't a communication and that there was a problem with the communication because here is the content of the communication. She can't say that. And she doesn't have to admit or deny. She could admit she engaged in prostitution. It still does not resolve that central question. The prosecution had that information. All they had to do was put in the felony complaint. The undercover called the backup team or the arresting officers, and that's how this happened. There's no reason for them not to have done that. Other than saying anything about the communications, all the defendant could do is say, when these officers entered the hotel room, I wasn't doing anything illegal. There was nothing illegal in view. That's all she can talk to, is what existed at the time they entered.
But counsel, how is that different from the a motion to suppress where an individual states that they were just walking down the street and all of a sudden the officers came upon them? Isn't it the same thing in terms of the lack of specificity and factual allegations to support a motion to suppress?
it depends what the predicate was for that transaction, for that arrest, rather.
So
If
there was
the
a
officer
so
says,
the defendant did not know that there was a 911 call, individual with a gun or whatever, and so they were not aware of that communication.
okay,
Okay.
so if they're
So
walking
how's
down,
that different from the situation we have here?
meaning that if they're walking down the street and all they can say is, I did nothing,
Right.
and then and the police descended on me, that's
insufficient, right? Those are insufficient factual allegations to support a motion to suppress. Are they not?
No. I mean, those facts are sufficient to get a hearing. It's almost akin to what the facts were in Burton, the Court of Appeals case. The defendant didn't know why, they just alleged that he was there and they recovered drugs from his pocket.
Counselor, is it your position that just a straight denial of being in, is it your position that just a straight denial of being involved in any criminal activity is sufficient to warrant hearings?
No, not under all circumstances. If it's a buy and bust and there's the undercover, the felony complaint says the undercover told the backup team, this is the person I sold drugs to, and they come in and that's all in the felony complaint, then I would agree that the defendant has to contest the basis, the actual facts of the transaction. In this case, she can admit she was involved in prostitution, but there's no way for her to know that the undercover told the backup team about this. Am I answering your question?
You have.
Okay, thank
Okay,
you.
thank you.
Thank you, thank you both. Gardner versus Virtuoso.
Good afternoon, Your Honors. May it please the Court, Mark Balin on behalf of defendants, appellants, Virtuoso Limited and its CEO, Matthew Upchurch. We are appealing the order below insofar as it denied our motion to dismiss counts 1 and 2 of the complaint for defamation and product disparagement. And the defamation in this case can basically be broken down into 2 categories. There's written statements, and then there are these oral statements. And the written statements, it's clear what those statements were. We have other defenses as to why they should not be actionable, including consent and a common interest privilege, which I'll get to in a moment. But I'd like to first address the oral statements because they do not meet the threshold requirement under New York law to plead the statements in hoc verba, which is the requirement under CPLR section 3016A, which requires that the statements alleged be made with particularity. Specifically, in an action, CPLR 3016A states, in an action for libel or slander, the particular words complained of shall be set forth in the complaint. And in this complaint, the actual words themselves are not set forth. There's summaries, there's paraphrasing, and this court, going back hundreds of years, and as recently as just a few years ago, has reiterated that you can't just allege the sum and substance or the tenor and effect of the words. You have to allege the particular words used. And in this case, it's very important because we have, my client runs this travel network of travel agencies and travel suppliers. The plaintiffs are travel suppliers that were in that network, and the statements that are alleged, that they allege were defamatory, were supposedly made to different travel agencies, but we don't know exactly what was said, who said them from my client. We don't know who received the statements, other than they allege that a travel agency company, but we don't know the particular person. And the only thing that's alleged, there is some specificity in the complaint to the extent that it shows there's some allegations about how they interpreted the statements, but there's nothing to suggest what the actual words used were. And that's in violation of section 3016A.
So I'm looking at the complaint. It says particular words complained of. Are the particular words complained of? Is that the only mention of the words of what was stated?
The particular words complained of?
I'm looking at the complaint. It says, including the online posts, the directed statements, and other statements regarding Gardner Heritage revealed in J.G. Black Book are the particular words complained of. That's under count 1. Is there any other reference or statement as to those words complained of?
Yes, there are the written statements, and we refer to them as the February statements and an April statement. And those were written, and those were published on the Virtuoso network, which is the members of the network can log in and they can see what was written. And in those statements, and there's a statement made that the plaintiffs, Heritage and Revealed, two travel supplier companies that were owned and operated by Jenna Gardner, another plaintiff, that they were being placed on probation. And the reason they were being placed on probation was that there were complaints about them not paying timely commissions and other problems relating to their work.
So, counsel, can you address the consent issue? Because, yes, the plaintiffs consented to you telling your constituency that they're on probation, but it doesn't say, and I consent to you telling them why, even if it's false. So are you saying, so my question to you is, the consent doesn't say anything about you, it says you have discretion, but it doesn't say, and you can make a false statement. What it says is, sure, tell them I'm on probation, but it doesn't say anything about, and tell them why, even if that's false, right?
Right.
It doesn't say for any reason, or that's not in the consent.
Okay, yes, and so in here we're referring to specifically, I think, the written statements, because we know what those statements
Yes,
were.
I know we're all,
And-
yes, we know this case,
Okay,
right?
and
Let's
so-
just address that.
Right.
Consent isn't that broad.
Right, well, again, the consent is in the contract, and the contract
Yes.
has the, I think the
Is it that broad?
Yes, well, the language that you focused on, Your Honor, is that Heritage and Revealed specifically consented to Virtuoso notifying its members of the change in status.
That's it. But you did more than that, right?
Well, there are other
Did you
provisions
do
under
more
section
than
4.6
Did you
in the
not?
agreement.
Did you say more than they're on probation? You said, and here's why, right?
Right, and in the other statements in
Why does the consent cover that?
Right, and I think that if you look at section 4.6 as a whole, it says that if Virtuoso determines that Heritage or Revealed were quote-unquote problematic due to concerns, including such issues as outstanding commission payments, outstanding fee payments, operational problems, financial instability, service issues, or other problems determined by Virtuoso. So that's the exact language I'm quoting from
Then you
section 4.6.
said not trustworthy, and neither her nor her companies should be trusted.
We did not say that. They alleged that that was a paraphrase of what was said, but those exact words are not alleged anywhere in the sense of that the statement was made by person A to person B, said this statement. And those are just, again, summaries, and that gets back to the issue of 3016A, which the particular words used have not been alleged. Why she was...
Back to Judge Scarpulla's point, though, so one aspect of Section 6 defines the circumstances under which you can characterize a vendor or a client as problematic. And then later on, it talks about specifically that the preferred supplier consents to Virtuoso notifying its members of a change in status. But then, although 4.6 gives you the right to label a client or a vendor problematic for specified reasons, this consent is rather narrow. Is it not?
No, I would argue that if you look at the provision as a whole, that if there's going to be a change in status, then everyone would know that the change in status is due because these companies all have similar contracts, so they'll see this type of language. They will know that that's because of, could be outstanding commission payments, outstanding fee payment issues, operational problems, etc.
But that's not what it says. I mean, it doesn't delineate those various items that you just mentioned.
I'm sorry, Your Honor, but it does actually. It does say in section 4.6, it says that if Virtuoso determines that Heritage or Revealed were problematic due to, and then quote, concerns including such issues as outstanding commission payments, outstanding fee payments.
Counsel, it does say that. It says exactly what you're saying that it
Right.
says. But what it doesn't say is that we're giving you permission to say not only we now probationary, but we're probationary because X, Y, and Z. From what it reads, it just says you're allowed to say we consent, that you could say that we're on probation.
Right. And Your Honor, our position is that if you look at the provision as a whole, that consent is covered. We also have the privilege, the qualified privilege, the common interest
You're going
privilege.
to be able to address that with us on rebuttal.
Okay, thank you, Your Honor.
Time is up.
Good afternoon, James DeCristofaro on behalf of the respondents. So the first section I'd like to address is this 3016A issue, which talks about what's necessary for the pleading requirements for a slander. Nowhere does it mention that the words need to be in the quotations, which is what I think my adversary is suggesting. And in fact, Torres, and as the case Torres, which is what the lower court cited, said that quotations are explicitly not required. Moreover, as the court has also pointed out on several occasions, there are directed statements.
Isn't the problem here, at least as to the 24 oral statements, that you make the same, you use paraphrases, but the paraphrases are identical for each of the 24.
Well, they're not qualified though either. If the court takes a look at some of the cases, some of the cases where the statements are not accepted and do not provide a basis for continuing the complaint, they are qualified with words like statements to the effect, this, that, or the other thing. If you look,
All right, let's start with this. Let's start with the statute, right?
Yeah.
The statute does require that you plead the particular words, correct?
correct.
Right. Okay. So while I guess in some of the cases, and I don't dispute it, some latitude is allowed. You don't have to have it in quotes necessarily, or it used to be in the Latin Mohawk whatever. Your adversary aptly said
In hoc verbi, I think is what it is.
in hoc
Yeah.
verbia, right. But it's somewhat relaxed now, but it didn't disappear. So why is it okay when the paraphrases that you did, it wasn't, to this particular directed person, they said X, Y, and Z. To this particular one, they said in substance A, B, C. But you have these kind of generalized statements, and you say, as to all 24, they were all told in substance this. Why does that meet the standard?
Because, Your Honor, if you look at the context of the complaint, if you look at the context of the facts here, this was all done within 1 or 2 days. And if you look also at the words of our complaint, it said that Matthew Upchurch of Virtuoso, he ran Virtuoso, and he used Virtuoso as a megaphone and directed his staff to basically annihilate the plaintiff here, Ms. Gardner, who is about to do $30 million this year and has a storied history of building company after company, or excuse me, a travel company, and acquiring other companies. And if you look at the directed statements, if you look at the paragraph after the directed statements, which are 38A through X on record pages 33 through 37, it shows within the first at least 10 or 15 of those that it was the same phone calls made to person after person after person after person. And if I might add as well, those directed statements are within the...
Wait a second, is it your position that everyone in the staff said the same thing to every person on the other end?
Well, if you look at the allegations in the complaint, the paragraph 38 says what was said during those phone calls.
Generally, right? Generally.
Well, the fact that those...
Some and substance, but your position here is every single one of my employees, or their employees, I should say, his employees, Upchurch's employees, said exactly this, but not really this, and this, generally this, and this. That can't possibly satisfy the statute, can it?
I don't know, we'll have to check it out during discovery, but however, first of all, we didn't say that every single one of his employees made those phone calls.
Well, you say, paragraph 38, you say between February 6 to February 15, 2019, employees at Virtuoso at the direction and instruction of Upchurch contacted at least 24 travel companies and said said whatever.
Yeah, so the
You
allegation
are
is,
saying, as Justice Scarpullo just said, that the employees, every single employee, or these employees said the same thing to these 24 travel companies.
that's the allegation, correct. And we don't know, during discovery, he may have given his employees a script to read and go over each one of these things with each person. The point is that this information is within the exclusive knowledge right now of the defendants.
Well, not really. I mean, the 24 agents, you can speak to them. Nothing's stopping you from speaking to them and getting the information.
Right, but they're not a party to the litigation.
You don't have to be a party to the litigation. Your client's somebody in the industry. She picks up a phone. What was said to you? Some will tell her, some won't tell her.
Right, and so what we've accumulated over the process of putting this complaint together are these directed statements.
Okay.
And the directed statements, are not generalizations. They're very specific as to what was said with regard to trustworthiness and so forth.
Okay, let's hear from your adversary in rebuttal. And we recognize this is a complex, multifaceted case. We do have your briefs, and we are familiar with them.
Thank you.
Because I know we're not getting to all the issues today.
Your Honor,
Go ahead.
real briefly, I would like to address the qualified privilege, but before I do that, on 3016A, counsel made the comment about how it doesn't have to be in quotations and reference some of the two of the cases that were cited below by the trial court judge. And while that might be the case, those cases, though, there was much more specific information that was given in those cases about the statements. So we knew what we were talking about when we were litigating this.
So
Counsel
let me
says
just
we can, I'm sorry.
direct you to the common interest privilege, and why is it that the plaintiff has not alleged not actual malice, personal malice to overcome, at least at the pleading stage,
Right.
the qualified privilege?
Right, and that's because, Your Honor, there's a Court of Appeals case, it's Lieberman, we cited in our papers, and it basically says that the plaintiff has to allege that the sole cause of the malice is to make the false statement.
And so you're saying it's mixed here, because they do make the allegation, and plus they wanted to ruin her financially so that he would be
Right, well,
and
not
in
so
a
much
mixed case like that, that's a problem.
Exactly.
Absolutely.
It's not so much that they might allege about the ruining financially, but that's really not the critical thing. The critical thing was that my client they alleged that my client had a business interest in doing this. And we made a motion under 3211A1 where we attached some of the documents to show that these were emails that they had gotten, our client had gotten. So there was an interest there as well for them making the statement that they made, that they were getting these reports from their clients.
Well,
And
sir,
so,
under Lieberman, isn't the inquiry whether the sole motivation, whether it was the sole motivation? So isn't motivation something that really needs to be tested but by a fact finder?
right, but they've alleged multiple motivations here. That's just it. It goes to their allegations. And our point is, in the complaint, they've alleged more than one motivation. And under the law, they should have only alleged one single motivation to overcome the privilege. So I see my time is up. If there's no further questions, thank you very much.
Thank you
Have a good
both.
day.
The next case is Markov versus Barrows. You can proceed.
May it please the court, I'm Sanford Young. I represent the plaintiff appellant. The underlying case, the case within the case is a clear, straightforward case. And I submit that if that case was brought on its own, not as a legal malpractice case, there would be no question that it stated a cause of action. In fact, it stated clearly a cause of action in the original case, where Justice Ramos recognized the validity of the case, and it states a straightforward misrepresentation for purchasing something that's described as having diamonds, which are referred to as brilliants, and it did not have that. Now, the standard for which the court below is asking us to prove it seems very nebulous. The complaint is devoid of any specific factual allegations the plaintiff would have been successful in the underlying action but for defendant's negligence. How does one do that? We state what the cause of action is, we go through all of those steps, and it's a lawsuit, and the only way to prove that lawsuit is by the submission of evidence.
So, counsel, if your claim is that your fraud claim against Stack and Stack, the auctioneer, states a claim, correct? On
Yes.
basis of fraud,
Yes.
correct? So you need a material misrepresentation, and you need justifiable reliance. How do you get over justifiable reliance when the catalog says, you're saying that whatever it was, your client found out literally 2 minutes before the statute ran that the diamond, that the coin didn't have diamonds. And you're saying that the Stacks and Stacks misrepresented that fact.
Yes.
But the catalog says, Stacks and Stacks does not make any warranties about how these things are described and what they contain. How can you allege justifiable reliance with that catalog?
Well, I'll concede that the original complaint that I drafted does not state things in detail because it refers to the prior lawsuit. We made a motion to amend the complaint in which we go through all of the details, lots of exhibits.
So how do you get around the statement in the catalog that you are saying was a misrepresentation? I do not warrant. Stacks and Stacks does not warrant what's in any of those coins.
I'm not sure I understand the question, Your Honor. The catalog describes it as having brilliance, and it uses the word brilliance several times as a noun.
And it also says the auctioneers disclaim any warranty as to the description of the items, right?
We're not suing for warranty, breach of warranty. We're suing for fraud.
Okay, so an element of fraud is justifiable reliance, right? You and I can agree on that. You have to allege justifiable reliance. You can't, you have to, that's one of the elements of fraud, right?
I'm not sure, I'm sorry, I'm not hearing Your Honor.
To allege fraud, you need to have a material misrepresentation, right? That's communicated to you, justifiable reliance, and damages. 4 elements, correct?
Yes.
You have to allege all 4 elements. If one element is missing, the claim fails. So you have alleged, I justifiably relied on the catalog, which says this has diamonds in it, right?
Yes.
And I'm saying to you, how do you get around the fact that the catalog also says we, Stacks and Stacks, make no representations or we make no warranties about what is in those items.
A party can't
How can you allege justifiable reliance in that case?
a party can't exculpate themselves from fraud. If I'm going to commit fraud in someone, I can't exculpate myself by saying I make no representation, and on the other hand, make that representation.
People do that every day and say, I'm not warranting this, I'm not warranting that. Statements every day say, I'm not warranting. Accountants say, I'm not warranting whether or not these documents are good. I got them from my client, this is what I got. I don't warrant their accuracy. I think that people do that every day.
But not for fraud.
Specifically for
Bernie
this
Madoff
reason,
could
right?
not have exculpated himself by saying, I'm not making a warranty of the authenticity of these statements. It's a fraud, and if someone commits a fraud, they're liable for that fraud. They can't make themselves not liable for it. I just want to add that the metal was encapsulated in plastic. So I know that the defendant argues that he could have inspected it, but he could not inspect it because it was in the sealed.
So, counsel, I just want to be clear. You're arguing that even though it says that Stacks further expressly disclaims all warranties relating to the grade, conditions, identification, et cetera, that they are not, that you are, that does not relieve them from liability, even though they expressly state that.
That is my position. I think that's a clear position. I don't see how it could be anything other than that.
So, and that's based on what? Bernie Madoff? What is it based on?
That you can't exculpate yourself from fraud. If you're going to commit a fraud, you can't say, I'm not liable for fraud.
Would that be fraud by just saying, we don't know, therefore we can't warranty anything because the items are brought to us?
I think that
So
goes to the,
therefore,
that goes to the scienter, whether or not they knew it was fake. And I understand that we would have the burden to demonstrate that they knew that it was not as represented. But they can't say we didn't know it. We would have to prove that they did know it. And that's the only thing that would exculpate themselves, not by just putting in words on terms of sale and saying we make no representation when they do make a representation. Again, I remind the court, we're not suing for breach of warranty. We're not suing for breach of contract because of the statute of limitations. We're suing for fraud. Thank you.
Thank you.
Good afternoon, Your Honor. Sarah Prager for Defendant Respondent Michael Barrows. This appeal represents plaintiff's latest attempt to manufacture a claim for legal malpractice where one does not exist, as was just discussed during counsel's oral argument. He has not stated a claim for legal malpractice.
Well, let me ask you this. What do you say to counsel's statement to us? I need discovery on whether or not they knew the statement was false.
Well, first of all, nothing has, the original complaint is entirely deficient, which.
Okay, but we have, let's just, okay.
So are we talking about the amended complaint?
Yes.
Okay, so in terms of the amended complaint, there has been no allegations that would suffice to establish the but-for proximate cause element of the legal malpractice claim because there are no allegations to support the underlying claim of fraud. As set forth in our brief, there are various defenses that completely undercut the probability of success that plaintiff is attempting to claim.
Well, they, you know, certainly on the amended complaint, they don't have a high burden here. Well, the only reason that you wouldn't allow the amendment is if the claim on its face was palpably improper. So the existence of even strong defenses wouldn't necessarily cut against the amendment of the complaint, would it?
No. However, the amended complaint itself still just includes allegations and documentary evidence in an attempt to persuade the court of something that isn't there. There's no substance to any of the allegations that are being.
Let's get specific. So you have this catalog, right? And is there any indication or any allegation about who provides the catalog?
There's no, but there's also no allegation as to when the catalog was received, when he reviewed it.
You have to answer my question.
My apologies.
Is it the auction house that provides the catalog?
Yes.
All right. And who provides the information to the cataloger to create the catalog for the auction sale?
I believe it was the auctioneer.
The auctioneer, right. So now the question becomes, you know, and I think it's the same question that my colleague asked your adversary. It has to do with reliance. Could there, as a matter of law, be an issue of reliance here when there's a disclaimer? And if your answer, which I suspect would be no, tell me why that is.
Because he also hasn't, the amended complaint doesn't contain any allegations that plaintiff or any other buyers actually read the catalog prior to the auction, thereby placing the reasonableness of the reliance in question. Plaintiff is still required to adequately plead the underlying claim, which he has not done here.
So, and what effect, if any, does a disclaimer have?
Well, that's just another factor to consider as to how, as to why the claim would be unsuccessful and why the amended complaint is patently devoid of merit.
So you think it would be a viable argument for the plaintiff to say, I never read the catalog and I wasn't required to read the catalog?
No, I'm saying that that just goes to his inability to state a claim for fraud because the justifiable reliance prong has not been alleged or met.
So you're saying that in the complaint, he actually never actually said, I read there's no allegation that he actually read the
I'm saying that the proposed amended complaints added allegations relating to the justifiable reliance prong are conclusory and factually insufficient. It does not contain any allegations that plaintiff or other potential buyers actually read the auction catalog prior to the auction, thereby placing the reasonableness of the reliance in question.
Well,
But there has to been, I'm sorry, go ahead.
No, just because I don't want to muddy the waters here, but other potential buyers, he doesn't have to allege that other potential buyers read it. But your claim is that there's no allegation here that on the underlying fraud claim that the buyer, the actual buyer, read the catalog. Is that your argument?
Yes.
Potential other buyers are irrelevant here.
Yes.
But the claim is that the sash or the metal, or whatever, the coin or whatever it is, did not contain brilliance, did not contain diamonds, right? And they believed that it would contain diamonds. So they had to have read something, or what led them to believe that this metal or coin or whatever would contain brilliance.
But he hasn't alleged any of that. There's nothing that's alleged. That's our position, is that he hasn't even set forth any of the allegations to sufficiently state a claim for fraud, and therefore has not stated any allegations in support of a legal malpractice claim because the proximate cause element has.
There's nothing in the amended complaint that the item didn't contain brilliance. I'm confused. I have to admit.
That's what the claim is, but the actual elements to state a claim for fraud are not there.
So are you saying that although the complaint says the item did not contain brilliance, that somehow there's nothing else that said, there's no further allegation or statement that it should have contained brilliance, and that's why they bid on it, was because it was their belief that it would contain brilliance?
He only contains a generalized allegation that the auctioneers knew or should have known that their representation was false. That's what the complaint says. So,
well, what's wrong with that? I mean, honestly, you know, they were auctioning off the item. They provide the description to the cataloger. The description is provided in the catalog. The description says brilliance. Shouldn't they have, isn't it fair to allege, at least at this stage of the proceeding, that they either knew or should have known?
For $690,000?
Well, he still has not alleged that.
He doesn't have to prove his case.
No, and that's not what I'm stating. I'm stating that he still has not alleged all of the elements to a claim for fraud.
Because you're saying because he didn't say that I looked at the catalog before I bought.
Correct. And also he's a expert in Russian coins and metals. That's what's alleged in the amended complaint. He had a duty to undertake a reasonable. He had the obligation to do his due diligence before purchasing this metal.
Well, that is irrelevant on an issue of fraud. If you defrauded, you defrauded. Now the question is whether the elements of fraud. There's nothing about his duty here to know because he was a smart guy about Russian metals.
But
I think we're getting everything all mixed up here.
But he also is required to prove a high likelihood of success on the claim. If he hasn't even stated a proper claim
all he has to prove is that he has to have a complaint that's not palpably devoid of merit. It's a pretty low standard, I think. You're saying he's not going to be able to prove it. You may be right, and it may be defensible. You may be right about that, but the question is, can it go forward on this pleading?
I just don't know that he has not actually pled the but-for proximate cause element, which is, again, he relates everything back to Judge Ramos's decision and order in the lower case discussing the viability of two potential claims on the face of a motion for summary judgment. That does not, by any means,
No, it's actually a stronger standard on summary judgment, but all right.
they just failed to.
Let's hear your adversary's rebuttal.
Thank you.
Thank you.
Just briefly.
So let me just ask you straight up, in this, do you allege that that your plaintiff looked at looked at and relied on the catalog?
Absolutely.
Okay.
Absolutely.
You're saying that there are allegations in the proposed amendment to
He
complaint.
relied on
Prior to the auction, he looked at the catalog, he looked at the specific thing, and he relied on it.
Yes.
Okay.
Counsel, it's, correct me if I'm mistaken, but it's my understanding that your client or you provided a glossary of terms used in the industry which defines brilliance, and that was done in reply. That wasn't attached or somehow connected to the amended complaint.
I apologize. I'm not hearing Your Honor.
Correct me if I'm wrong, but my understanding is that your client attached a glossary of the terms that's used in the industry, which included a definition of brilliance, right, as to mean diamonds. That was included in reply. That was not a part of your amended complaint. Is that right?
Well, the brilliance is the center point of the fraud.
But the definition of it, did you provide that in the amended complaint?
It's alleged in the amended complaint. I wanted to point out that Judge Ramos already held that it was a valid cause of action. If I could read, he says, quote, defendants have not submitted any evidence that would refute Plaintiff Markov's contention of a misrepresentation or reasonable reliance as a matter of law, and therefore that the court cannot hold on this record that there was no misrepresentation on the basis of the definition of brilliance, unquote.
Okay, so
we're all going to ask the same thing. On that motion, are you saying that the statement "I don't warrant anything" was put up before Ramos?
This issue was before Judge Ramos.
Yes, I know that. So I'm asking you, was the terms of the catalog and in terms of reliance, was that before Ramos? Was that argued before Ramos? Because I didn't see it.
I don't believe that specific argument.
It wasn't.
Let
I didn't see it, but maybe.
Very sophisticated parties in the underlying case, and they're not making that argument. And I believe they didn't make that argument for the reasons that I argued earlier, that you can't exculpate yourself from fraud. Thank you very much.
Okay, thank you both. Okay, the last case to be argued today is People versus Cruz. You can proceed.
Thank you, Your Honors. Good afternoon, and may it please the Court. Katya Barone from the Center for Appellate Litigation for Appellant Jonathan Cruz. This is a case where suppression should have been granted because the police officers involved offered incredible testimony to justify an unconstitutional automobile search. Police officers offered two false justifications for entering the car in which Mr. Cruz was a passenger. First, officers testified to the smell of marijuana from outside of the car, even though the only marijuana recovered from the car was two small sealed bags of unburnt marijuana, one located in the co-defendant's pocket and the other located in the passenger side door pocket. Second, one officer testified that he could not see through the passenger side window, requiring the officer to open the passenger side door without permission. But photographic evidence demonstrates that the passenger side window was not tinted and the interior of the car was visible.
Isn't that evidence that you're alluding to? Isn't there a question as to whether that statement is accurate? There were photographs that were submitted, I think, by the prosecution that shows a vehicle what appears to be heavily tinted windows. And then there's a photograph submitted by the defense that shows that the windows are not heavily tinted. But the difference is that this incident happened here at 4 in the morning, I believe, or somewhere at night. And the photographs that you took of the car or that were presented by the defense of the car that show that the windows are not that tinted was in broad daylight.
Right, Your Honor. The photos must be taken in conjunction with Officer Rupert's testimony on the record. Officer Rupert is the officer that opened the passenger side door. He testified in the hearing, if I may direct your attention to pages 90 to 92, he waffled in his testimony on whether there was a tint or there was not a tint that precluded him from being able to see inside the car. And
Well, it wasn't only that. Wasn't there also testimony that they had asked the driver, the passenger, to lower the windows and to roll down the windows, and they did not do so?
So the officers testified to asking the passenger, Mr. Cruz, to lower the window. In the record, it shows that the driver told Detective Sepulveda, who had approached the car from the driver's side, that that window was broken and that Mr. Cruz could not lower the window.
Okay, so if he couldn't open the window, that's when the officer opened the door, right? Is that correct?
That is what the officer's testimony indicates his reason for opening the door. However, there was no need to open the door in this situation.
Why not?
The officers were simply effectuating a traffic stop. Nothing in...
Well, aren't officers allowed, pursuant to a valid traffic stop, to ask passengers to get out of the car for their safety, with nothing more?
Well, there was nothing to indicate that the officer's safety was a concern.
Do they have to establish that in order to ask, on the prevailing case law, do they have to establish any reasonable cause, probable cause, any belief that they're somehow subject to danger?
There should be at least reasonable suspicion that there is some illegal activity.
Is that your opinion or is that the law?
That's the law, Your Honor. They had probable cause to stop the car for a traffic violation, but whether they had any reasonable suspicion to then just suddenly open the car door, it's not justified, Your Honor.
Counsel, that's my question, is that they stopped the vehicle. They certainly can approach the vehicle. They can approach the passenger side. They can approach the passenger. They asked that he roll down the window. He's unable to do so or doesn't do so because the driver says that the window is broken. So then they open the door, which I think is reasonable under the circumstances because he didn't roll down the window. And it's when he opens the door that he allegedly sees the drugs in plain view in the side of the door.
Well, Detective Sepulveda, his partner, was already on the driver's side of the car and had heard, and he says so in his testimony, that he had heard that the window was broken. He already had asked the driver for his paperwork, his license in that situation. There was nothing to indicate that suddenly the safety was a concern.
Why not? The window is up, so the officer on the passenger side is standing there next to the passenger side of the vehicle with the window up. It's tinted, whether it's heavily tinted or not heavily tinted. He doesn't know what the passenger is doing. Should he not be able to see what the passenger is doing? And the only way he's going to be able to do that is by opening the door, again, because the window won't roll down?
Detective Sepulveda could see into the car. And additionally, Officer Rupert had a flashlight.
Well, you got two officers. Shouldn't both officers be able to see into the car?
Officer Rupert had a flashlight, and he indicates that at some point he could shine the flashlight into the car as he was approaching it from the back side of the vehicle. So again, I would ask this court to focus on the credibility of the officers. Officer Rupert, he waffles in his testimony. He says there was a glare at one point as well. He says that it was actually the glare, not the tint that prevented him from seeing inside the vehicle. That, coupled with the patently incredible testimony.
Counsel, the point is, whether there was the glare, whether it was the tint, the point is he was consistent in saying that he couldn't see in the vehicle.
But the officers we're, again, trying to focus on the credibility of the police officer's testimony because that and the photographs was the only evidence offered at the suppression hearing that the judge had to rule on. And so the officer's testimony being inconsistent asks us to question whether the officers are just tailoring their testimony to justify an unconstitutional search, which is not appropriate in any case.
All right, thank you. Let's hear from your adversary.
May it please the court, I'm Philip Tisney for the respondent. There was a valid appeal waiver in this case, and even if there wasn't, The suppression decision involved no factual or legal error, as we've set forth in our brief. If the panel have any particular questions, I'd be happy to answer them. Other than, I'd be happy to rest on the brief. We'd ask that you affirm. Thank you.
Thank you. All right, rebuttal?
I would just like to make the point that the purported appeal waiver is invalid in this case. The trial court mischaracterized whether certain rights remained after the defendant enters a guilty plea. That does not allow the defendant to then make a knowing, intelligent, and voluntary decision about whether or not to enter into an appeal waiver. So it's our position that the appeal waiver is invalid and that this court is able to review the issues that we have raised in our briefs. Okay. If there are no further questions, thank you.
Any questions? Oh, thank you. Thank you both. Thank you for waiting such a long time to be called at the end of the calendar. We appreciate your patience.
It's okay, no problem.